Okay. Um, Welcome, everybody. Thank you so much for being here. People are going to be trickling in from the waiting room. My husband, Patrick, is also on the line, so he will be admitting people as we get started. Thank you all so much for being here on a Wednesday evening. If you have little kids like I do, I hope they are in bed already. And then I also hope all of us will be in bed soon after this call. I thank you so much for joining me this evening. I really do appreciate it. Um, Before I get started, I wanted to ask you all to introduce yourself a little bit. So if you could find the chat feature or the chat box, looks like a little speech bubble, should say chat. Click it and introduce yourself. Throw your name into the chat. Um, Tell us where you're listening from. That's really helpful for us. I serve clients in both Pennsylvania and Ohio. So it's really nice for me to see where you are all listening in from. If everybody is from the same state, I can tailor our information a little bit more specifically to this state. So introduce yourself, tell me your name, first name, last name, tell me where you're listening from. I'm going to be keeping an eye on the chat throughout the Pennsylvania. Hello, hello. I see Pennsylvania. I see some New Jersey. Very great to see you all. Thank you for doing that. Um, I'm recording tonight's presentation so we can send it out to people who registered but weren't able to attend. But at the end, I'm going to stop recording and then I'm going to answer your questions live. So that's a little bonus that you get for being here live with me tonight. A little bit of one-on-one Q&A at the end. So I really appreciate you guys for being here and I don't want to waste your time. So I'm going to jump into things. But before I jump into sort of the substance of tonight's presentation, I wanted to introduce myself a little bit more so that you know who you are speaking to and you know who's sharing this information with you more. So my name is Emily O'Geel. I'm an attorney. My husband Patrick is also an attorney. We run this firm together as a family. We love doing that. We have 5 children. Our oldest is 10. Our youngest is 7 months old. So we're very busy. We moved to the Lehigh Valley area about a year and a half ago. But my husband is from this area. He grew up in Allentown. His entire family is here. So it was really nice to move back, actually, and to be really close to family. That's really helpful, especially when you have a lot of little kids, to be close to family. We were living in Ohio prior. That's where I'm from. That's where I grew up. And that's where we began our legal careers too, at 2 separate, really large law firms in downtown Columbus. My husband was doing medical malpractice defense. So he represented, doctors and hospitals really in like the worst case scenarios when healthcare goes wrong, basically. He specialized in what's known as baby cases. So basically, births gone wrong, honestly, where mom or baby dies. Really tragic, really sad stuff. So for him, death was not really, it was a really everyday reality in his job. It was not for the elderly, it was for families. It was everybody. I was doing estate planning from the very beginning of my legal career. But at the really big law firms, the type of estate planning you're really doing is for the top 1%. That's who can afford the really big law firms, those really high hourly rates. It's the ultra wealthy. They own car dealerships and large real estate portfolios, and we're doing the most sophisticated legal techniques to take care of their families in the best way possible and save them the most amount of money. It's a great job. I learned a lot, but it wasn't very relatable. I didn't grow up in the top 1%. That's not where our family is. So when my husband and I wanted to make our first estate plan to protect our kids, we had 3 little kids. This was several years ago at the time. We went to another attorney who was recommended, I thought sort of specialized in working with families that were like us, maybe not in the top 1%. We didn't need to do sophisticated tax planning, but we wanted to take care of our kids. So we met with this attorney. He was very nice. Met with him for maybe 15, 20 minutes, got a big stack of papers, signed everything. That was it. A couple of years passed by. We had another baby. We bought a new house, moved across town. And in our new house, I was unpacking boxes and I pulled out this stack of papers and I realized that was our plan. That was the estate plan. And if something had happened to me and my husband in the last several years, it would not have worked. It would not have protected our kids. It would not have made things anything cheaper or easier for our family. We had basically bought an expensive pile of paper. I wasn't going to do anything for our family, and that that was our introduction to traditional estate planning, the way old school estate planning is done for middle and upper middle class families. And that honestly wasn't good enough. That wasn't good enough, certainly for our family. And I didn't think that was good enough for families in general. So that was our motivation to start OGL Law together, me and my husband, was the goal of providing a comprehensive estate planning service that actually functionally worked, that would actually make things easier for people's family when they passed away, that would really protect their minor kids, that would really make things cheaper and faster and simpler and less stressful, because that's usually why people are doing estate planning. So that's why we do what we do. Like I mentioned, my husband and I work together. We've got a bunch of little ones. We're either at football practice or at church, or there's babies everywhere. So that's a little bit about me. That's who you're speaking to. Um, Again, if you're just jumping in, thank you for coming. We welcome you here. Please find the chat box and introduce yourself. Let us know who you are, first and last name. That's really helpful for us to know who's here and who needs a recording. And also let us know where you're listening in from. So if we're all kind of in the same place, I can speak more to that. So find the chat box and introduce yourself. Now I'm gonna pull back up the slideshow and we'll get sort of into the meat and potatoes tonight. So I told you a little bit about myself, but now I want to talk about you and who this presentation is for. So this presentation about estate planning is for you if you want to make sure that you are not going to be leaving a mess for the people that you love. This is for you if you want to make sure that you are leaving behind a fully clear, practical plan for your family that's truly loving and is really going to take care of them the way that you want. So if you want to have comfort and assurance, knowing that your family is going to be taken care of, if you want some peace of mind about knowing what's going to happen to your assets if you become incapacitated or you die, then this presentation is for you. That's my goal. Estate planning is primarily something we do for the people who are depending on us. You get some benefit, that's true, but there are people in your life who will be greatly affected if you become incapacitated or when you die. So I want you to keep those people in mind as we're going through this presentation tonight. Think about who's going to be most greatly affected by your incapacity or by your death. Maybe you have minor children. Maybe you have aging parents who are depending on you. Think about the people that you would be doing this planning for. So now we're going to talk about the estate plan that you already do have. You might be thinking, Emily, I don't have an estate plan. That's why I'm here. But you do. There is a plan for what would happen to you. Either you have created some set of documents, maybe with cheap or free online resources, or with a more traditional old school attorney, or you have the state's plan. Because either way, there is a plan for what will happen to you and your family and your stuff if you're incapacitated or you die. And that plan might not be what you want. So we're going to look at that plan today so that you are clear. Because one way or another, you're going to leave this presentation this evening with clarity about what your practical next steps need to be in order to get your affairs in order the way that you want for the people that you love. Because most estate planning, the traditional kind of old school model of doing things, whether you do it yourself online or you're doing it with a more traditional attorney, that's about planning for death. And traditional estate planning processes, they just really don't take care of your family the way that you think they will. Often people are paying for expensive piles of paper that are not going to achieve the outcome they thought. That's what we did. I was speaking with a friend recently who she was telling me about her father-in-law who had a plan like this. He went to an attorney in Florida about 15 years ago. He spent $3,000 in order to keep her family out of court and out of conflict with his ex-wife. He thought there might be a problem, so he went to a lawyer to try to avoid it, got his stack of papers, put it on a shelf, never looked at it again, and then he died. And then they ended up in court and in conflict with his ex-wife. And she thought the attorney committed malpractice. So she started making calls, she looked into it, and it wasn't malpractice. This was just estate planning. This was just the way it was done. That's pretty typical. We do it really differently at OGO Law. So our planning is not just about planning for death. It's definitely not about putting in place a set of documents that you're never going to look at again. That's not going to work. We are planning for your life. We guide you through an educational process that actually begins with getting you more financially organized than you've ever been before. That really surprises people sometimes when I start with financial organization, but that's really important. It's a practical piece of this process. That's important to make sure that none of your assets get stuck in unnecessary court processes or they get lost to the State Department of Unclaimed Property. Then we look at your unique family dynamics and your budget to help you choose the right plan for yourself. And then we make sure that your plan stays updated throughout your lifetime. It's not a one-off transaction. It's more of a long-term relationship between our families so that we can be there for your loved ones when you can't be. We focus a lot on functionality and practicality. I might say those words a lot this evening because to me, there's really no point in making a plan, putting a plan in place if it's just practically not going to do anything when your family needs it. So let's review the state's plan for you. So if you don't have any custom documents, you haven't made anything online or printed anything out or gone to an attorney before, then what you have is the government's plan. You have the default law. And there is a plan for if you become incapacitated or when you die, and that plan looks like going to court. If you're incapacitated, you're going to court so that a judge can appoint somebody in your life, in your family probably, to make decisions for you. It's called guardianship or conservatorship. If you've died, the court process is called probate. The probate process is where the court is going to decide where your money goes, where your assets go, and in what amounts. And it might not be to who you would choose or in the amounts that you would choose. Court is very costly. There's attorney's fees, appraiser's fees, court filing fees, bond premiums, creditors' claims. It really adds up over time. A good rule of thumb is that your probate process, the court process your family would have to go through at your death, would cost about 5 to 7% of your assets going through the court process. So that looks like, just for ease of illustration, if all you own is one house and it's worth $500,000, you don't have a bank account, you don't have retirement accounts, you don't have life insurance, nothing else, just one house, that's probably going to cost your family $25,000 to deal with going through the court process. And all of that could have been avoided with a few $1,000s spent on a basic foundational estate plan. Also, the probate process is really slow. So the minimum kind of standard time frame for a probate process is between 12 and 24 months. I hear all the time from people about their relatives, their parents who passed away, and it's been 3 years and they're still in court. And during that time frame, your loved ones might not have immediate access to your assets. So, who would you rather have your assets available to at your death immediately? Your creditors or your children? Most people say their children. Probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. Plus, your family has to deal with all the stress of it. Sometimes people say, probate is just as stressful as a divorce. It is not a fun process to go through. And the court process is totally public, meaning anyone can go to the courthouse or go online and pull court records, and they can see what you own. And also, really importantly, they can see who's getting it. So one of the most common misconceptions I hear all the time, someone will call my office and say, I need a will. I ask them, tell me more about that. Why do you think you need a will? What has he saying that? And they say, I need a will because I just really want things to be easy and simple for my family at my death. I want this to be as easy and cheap as possible for them. A will doesn't do that. A will doesn't make anything faster, doesn't make anything cheaper. It does not avoid the court process. In fact, a will has to go through the court process in order to be validated. This is the will you're seeing on the screen of Jackie Kennedy. You can look up the will of, John Lennon, Babe Ruth, probably some of your family members or neighbors who passed away because they used a will and let their assets go through the court process. So my main point here is that a will is public and it doesn't avoid probate. Also, when a will enters the probate process, it puts all the creditors out there on notice that your loved ones are receiving money. So the only plan that avoids probate, that is private, ensures your children receive your assets when you want and how you want, it can also save you substantial costs and substantial estate taxes, is to use a properly funded living trust. I'm going to talk a little bit more about trusts in a minute, but that's the only way we can avoid this probate process. It's the only legal tool we have is to use a living trust. Throughout this presentation, I'm going to ask you guys to interact with the chat a little bit. It's helpful for me. It's really helpful for me to see what's resonating with you, what's important to you. It's also helpful for you to follow along as you're learning. You all found it and introduced yourselves. So find the chat box again. And if this court process sounds like something you want to avoid, if you don't want your family to have to go through the probate process at your death, put in the chat box, avoid court. If you are hearing me talk about how this process works, the length, the cost, it's public. If it's something you want to avoid, put in the chat, avoid court. Finally, with a will, and this is maybe worst of all, in my opinion, your children are entitled to all of your assets outright without restriction at 18. So I have a friend whose husband received $50,000 when he was 18, and then another $150,000 when he was 21. These were from loving family members who wanted to take care of him and provide for him in their wills. Sounds great, right? Well, as a result, he didn't go to college until after he was 30. He never really learned how to support himself financially. He treated people differently and they treated him differently. People found out about the money and it got strange, and he spent it all. It's all gone. He openly talks about those inheritances as more of a curse in his life than a blessing. He was too young to know what to do with the money. No matter how large the inheritance is, the typical inheritance is spent within 5 years of receiving it, which really speaks to, how we spend money as humans if it's just given to us. I'm seeing a question in the chat really quick about businesses through trusts. Yep, you can have a business that's owned by a trust. It's a great way for that business interest to avoid the court process. People don't really think about it, but if you're a small business owner, some of you might be on this call. If you have a business entity or business assets, those would be part of your estate and they would go through the court process at your death. And it can be really expensive and complicated. And it can also run your business into the ground if there's not a good plan in place and something happens to you. It's not great. So thank you for the question in the chat. So, some 18-year-olds are amazing. Some are very responsible and would know how to invest and save and plan for the future. Some are still in high school. Some would not know what to do with a cash amount of any amount, really. So you might want to ensure that your kids receive their inheritance protected from themselves, but also protected from things like lawsuits against them, protected from future creditors or even a future divorce. Most people, when they're married, they don't keep their assets separate. So everything is commingled and joint. So if you leave your child an inheritance, it could be $10,000, it could be $1 million, and they're married, and then they get divorced, your child's ex-spouse could end up with half of everything you left them. Not ideal. If parents leave their children an inheritance in a protected trust, the kids could use it to invest in a business or invest in real estate or just to keep it if they get divorced. So if you want to ensure that your children's inheritance is protected from themselves or from lawsuits, creditors, future divorce, no matter how old they are, Put in the chat inheritance. Find that chat box and put inheritance in there. We can be really thoughtful about the way that we leave an inheritance to our children in a way that creates wealth and actually protects our children from pretty bad outcomes. Before we move on from talking about your kids, if you do have minor children at home, I want to tell you two quick stories that could illustrate where your kids might be at risk, even if you have named guardians in a will. So if you've not named guardians in a will at all, we'll start there. 69% of parents haven't done any sort of, naming of guardians. If that's you and something happens to you and your spouse, a random judge is going to be deciding who raises your kids. That judge does not know you, doesn't know your kids, does not know your family, doesn't know your values, is just picking based on paper. It's not ideal. So several years ago, the Barber family was on vacation in Arizona. This was mom and dad and three boys, and they were in a car accident. Mom and dad died, but the boys survived. One of the mom's sisters came and collected the boys, and she said, I should raise them. I'm going to be their guardian. She then proceeded to cut them off from the rest of their family. She didn't allow them to see their grandparents, to talk to their cousins, to see their aunts and uncles. So another one of the mom's sisters sues for guardianship. She thought, this isn't going well. She should be the guardian. What ensued is over a year in court, over a year of litigation. There were 9 different lawyers involved, over $100,000 spent on court costs and attorney's fees. The judge did ultimately take the boys out of that home and place them with another one of the mom's sisters. But, who would have the Barbers picked? Who did mom and dad want? We don't know because they didn't write it down. We can be fairly certain they wouldn't have wanted their family stuck in a huge legal fight over the kids, but we don't know who they would have wanted to raise their kids because they didn't write it down. So if you have little kids at home and you want to ensure that you have a say in who would raise them if you aren't able to be there until they're 18, put in the chat guardians. You need to name guardians if you have kids under 18. It's better for you to pick than a judge. You know your kids, you know your values, you know your family. So put in the chat guardians if you have kids under 18. Even if you do have a will naming guardians, your kids could still be at risk of a bad outcome. And I realized this when I was out to dinner with my husband. This was when we had our first failed estate plan I was sharing with you guys about in the beginning. Our 4 little kids were at home, asleep in bed. We were out on one of those rare date nights. And I realized that if something happened to us on this date and we didn't make it home, the authorities are going to show up at our house and find our 4 minor children at home with someone who has no legal authority to stay with them. At that point, the authorities have no choice but to take the kids out of our home and into the care of strangers. That's when CYS steps in. That's when Child Youth Services steps in, basically foster care. That was not acceptable to me, that there was a risk that my kids could be taken out of our home into the care of strangers in the event of a family emergency. That was a huge gaping hole in will-based only, traditional old school estate planning. So I put in place for my own children, and I do this for all my clients with minor children, a kids protection plan. This kids protection plan ensures that there is no risk of your kids ever ending up in the care of someone that you don't know in the event of an emergency. So if you want to make sure that your kids are always with someone that you trust and that you choose, put in the chat protection. You need to think about your kids' protection in the short term as well as the long term when we're doing estate planning. The other reason that you might want to also think about kids protection planning for your kids is if there is someone in your life that you would never want to end up as guardian of your children. Your guardianship nomination is just a nomination, meaning it can be challenged. So a family member could step up to the court and challenge your nomination and say, no, I should be their guardian, not who mom and dad picked. If there is someone in your life, in your family, your family dynamics, that you would protect your kids from during your lifetime, you should protect your kids from them at your death as well. So you would need to exclude them from ever potentially serving as guardian of your children. So if that's your family situation, then you also need a kids protection plan. So if that's you, throw in the chat protection. So now we've talked a little bit about what would happen to your kids if you have minor kids. And we talked about your financial assets and what you own, what would happen under the state's plan if you become incapacitated or you die. But what happens to you? What happens to you under the state's plan for you if you become incapacitated? So let's talk about Terri Schiavo. Some of you might remember Terri Schiavo's story. This was a super infamous, very famous situation that occurred in the early 2000s. Terri was 26 years old when she had a cardiac event, no prior medical history. She collapsed in her home. She was revived, but she had been without oxygen for so long that she was in an irreparable vegetative state. She could breathe on her own, but she had to be fed and given hydration through artificial hydration, through feeding tubes, basically. What ensued for Terri and her family was a huge mess and a huge fight. After 8 years with no improvement, her husband, Michael, said, Terri wouldn't want to live like this. So he petitioned the court to remove her feeding tube. Her parents disagreed. They did not want to remove her feeding tube. They thought there was, a quality of life there. They didn't want her to pass away. So they fought. They fought in court. This led to, the president was making comments on this case. It went all the way up through the state courts. It led to several instances of her feeding tube being removed. Only 2 days later, the court reinstate the feeding tube, say they had to put it back in. We have no idea what kind of suffering Terri was going through. We have no idea the pain that she was experiencing. We also don't know what she would have wanted. Ultimately, they did end up removing her feeding tube and she passed away a couple weeks later. These terrible events really could have been avoided for Terri if she had properly executed a fairly simple legal document. And some of you might have a document like this executed, but I can guarantee that it's probably not comprehensive enough to cover what happened to Terri. As part of my job, I review a lot of estate plans. I read documents that other attorneys have created. And I would say 98% of the healthcare directives that I read are not comprehensive enough to speak to what Terri went through. So if you want to make sure that your wishes are comprehensive, that they're honored at your incapacity, if you have specific wishes about how you want your end of life care decisions treated, or you have specific wishes about who you want making decisions for you, then you need to get this planning done. So put in the chat healthcare. If you're concerned about a situation like what happened to Terri playing out in your life, find the chat box and put healthcare. So many people think that they can avoid all of the problems that we've been talking about tonight with either owning property jointly or designating a beneficiary for their assets or by signing a will. Joint ownership is really common. So if you are married and you own a home, you probably own as joint tenants. You do have the benefit of avoiding the probate courts if just one of you passes away. If one of you passes away, the other one fully owns the property, you have no court problem there. But once the second of you passes away, or if you go together, there's no probate avoidance. So joint ownership doesn't really solve the problem for estate planning purposes. Designating a beneficiary is great where assets permit it, but many assets don't permit beneficiary designations, like a house. And where you do designate a beneficiary, that person has unlimited control over the asset, meaning no asset protection. And worst of all, I see this all the time when I'm working with families and we take a deep dive into their financials. They've named their minor children as a beneficiary, which makes sense, right? For things like your retirement accounts or your life insurance policy, people often do their spouse first and then their minor children second. Well, minor children can't inherit. They can't inherit in this country until they're 18. So what that looks like is all of those assets going to court. They go to the court process, they get stuck there. A court-appointed guardian is going to oversee the assets, have to make a yearly appearance in front of a judge. It's expensive. It's the worst. It's not ideal. So, and we already talked about wills, just signing a will doesn't actually make this process easier for your family. The only way to keep your family out of court, either in the event of your death or your incapacity, is to have a fully funded living trust. And this means that you have a trust prepared that is custom drafted to say exactly what you want to happen with your family and your stuff at your incapacity and your death. And all of your assets are actually owned properly in the name of your trust. So if you already have a trust, maybe you have a trust, on this call, you've gotten a trust created before, chances are that it hasn't been updated since you created it. And it's likely out of date because either your life has changed or the assets have changed or the law has changed. It's also very likely that none of your assets were ever even owned properly in the name of your trust. If you remember earlier, I was talking about my friend's father-in-law who paid $3,000 for an estate plan that totally failed. This was because he got a trust prepared by a, highly reputable attorney, and then none of his assets were owned properly. And this is all too common with, form documents or cheap lawyers who are not properly guiding families to make informed decisions. And then they don't keep your plan updated or ensure that your assets are owned properly. So if you have an existing trust, if you're on this call and you know you have a trust created that's ringing a bell and you need it reviewed, or you know that your family needs a trust because you want to avoid these issues, you want to stay out of court, put in the chat trust. If you need a trust reviewed or you know you need a trust because you want to avoid probate, throw in the chat trust. When you create a trust, you also get to choose how to distribute assets to your heirs. You have so much more control and flexibility with a trust than using a will or relying on the government's plan for your family. So, how many of you, just think in your mind, how many of you would love to own assets that could never be touched by creditors, that could never be subject to estate taxes, and could never be taken away in the event of like a bankruptcy or a divorce? That would be great. I would love that. Now, what if I said you could have all of that asset protection, but you can't control the assets anymore? It's definitely a lot less interesting. Well, in our custom drafted living trusts, you can give your children assets that can never be touched by creditors, will never be subject to estate taxes, can't be taken away in the event of a bankruptcy or a divorce, and you can give them control. These are cutting edge techniques. This is what the top 1% are doing. This is the best way to create generational wealth and pass on your assets to your kids. I know that you would want these techniques considered in your estate planning if you have children and you care about creating generational wealth and you don't want them to squander it. Remember how I mentioned earlier that most inheritances are spent within 5 years of receiving them? This is how you prevent it. This is how you prevent squandering wealth. And you encourage your children to let it grow and to use it. So if you want to protect your kids' inheritance, if you are concerned about and interested in creating generational wealth, put in the chat wealth. You can be really strategic about the way that you pass on everything you've worked so hard for to your kids in a living trust. And it's the best way. It's the best way to create generational wealth. This isn't going to apply to most of you, but I am going to mention it just in case that there is someone on this call that would fall into this category. But you do need to know that if you have assets in excess of roughly $13 million, if you're married, roughly $26 million, or maybe you're expecting an inheritance that would put you in that category, you need to know that, your family could lose nearly half of everything above that number to taxes. There's very high, 40% death tax in this country. It's a very high tax. Doesn't apply to most people. That's a really high exemption number. Most people aren't in that category, but you might be. And you have a tax problem. You need to do some tax planning if you're in that category. I'm going to note really quickly that really high 13 million-ish per person, that's a really political number. It changes all the time. It changes depending on who's in office. It's going to sunset back down in 2026 to about 5 million per person, adjusted for inflation. That's about 7 million. So $7 million still doesn't apply to most people, but it might apply to you. And if it does, you need to know that you need to do some tax planning. So if you're in that category, throw in the chat taxes. You need to think about taxes if you have assets that are above those high exemption numbers, or your family's at risk of losing a lot of money. So put in the chat taxes if that is you. I see a quick question about types of trust. Yeah, we're talking right now primarily about living trusts, which is a revocable trust. But there are irrevocable trusts that we talk about, and I definitely get more in depth with people on deciding what type of trust is best for their family. Revocable, irrevocable, what's the best path forward? And that's a really family specific, nuanced question. But thank you for asking that, Maria. Last thing I wanted to mention right now, and this does apply to all of you, is that there are currently $4 billion in Pennsylvania in the State Department of Unclaimed Property. All of that property got there because somebody died and their family did not know what they owned. They didn't know where to find it. They didn't know about that bank account or that life insurance policy or that retirement account, and it got lost. It just goes. And this could really easily happen to you if you do not get financially organized and there is not a clear plan on how your family is going to find what you own and where it is and how to get it if something happens to you. So think about it for a moment. What do you own? And what could get lost if something happened to you this week? If you went out and ran errands, and then God forbid you didn't come home, what would just get lost because no one knows about it? A lot of our assets are digital now, crypto, bank accounts, insurance policies. What do you own that people just don't know about? If it's possible that some of your stuff might get lost at your incapacity or your death, you need an inventory. You need a really clear inventory of all of your assets, and you need a clear plan on how your family's going to find it. And I'm seeing another question in the chat about how long money stays in the State Department of Unclaimed Property. It stays there until someone claims it. So it just stays there. The government invests it and uses it. Your family just loses it until it's claimed, and there's a process for that. So if you think it's possible that your family might lose some of your stuff, if you don't have a better plan in place, put in the chat inventory. You need a clear inventory of all your assets in one place so that nothing is at risk of getting lost. So find the chat and put inventory if you don't already have an asset inventory. So we know what doesn't work. That's what we kind of have been talking about tonight, doing nothing, relying on the government's plan, having a will-based only plan, or even really getting an estate plan created by a lawyer who is just focusing on the documents, not ensuring the protection of your kids, short-term and long-term, not ensuring that your assets are owned properly or tracked on a clear inventory. That type of planning is just honestly going to leave your family in a really big mess in the event of your incapacity or at your death. And here's the other thing. What you need is completely different than what another family needs who's listening on this call, because your family dynamics are unique to you. Your assets are unique to you, and how the law applies to your family, well, that's unique. And your values, what you would want to have happen, is actually very unique to you. I will say it's maybe possible that a one-size-fits-all kind of DIY estate plan with online cheap or free resources might make more sense for you where you are right now. I'm going to share details in a minute on if you might want to DIY this if you're in that category. But because everyone's family situation and life is unique, that's why we begin all of our planning with a 2-hour working session. We call this 2-hour working meeting with me, we call it the Family Wealth Planning Session. The Family Wealth Planning Session process begins with that inventory of your assets, which we were just talking about. You need this no matter what. This is how you ensure that nothing gets lost when you die. Your family knows where it is, how to find it, so it doesn't go. We support you to create that inventory of your assets. We have a process that's really easy. We help you get that done. And then we have a 2-hour working meeting where we go really in depth We're going to get to know your family dynamics. We're going to talk about all of your assets and your goals, and you're going to get to know the law just enough so that you can make really informed decisions. So you know you're choosing the right plan for your family at the right budget, so that you know that you've made the most affordable and most functional route to take care of the people that you love. So you're likely wondering what the financial investment looks like for this kind of comprehensive estate planning. The regular cost of that family wealth planning session, that 2-hour working meeting with me, is $750. But in a moment, I'm going to share with you how you guys can get that meeting with me for free, plus an additional $250 off any planning you might choose to do with us in that meeting. Our average fees range between $2,500 and $6,500. That just depends on your family dynamics and your assets. And what's most important is that during your family wealth planning session, you'll choose where you fall in that range. You'll pick your fee. You'll have to weigh the upfront financial investment in an estate plan versus the ultimate cost to your family of having no plan in place, which typically looks like costing them a lot more financially, not to mention the time and the stress of it all. By the end of your family wealth planning session with me, you will know with certainty that you are making the best decisions throughout your life. And you will be only making an investment in an estate plan if it's going to save your family money and time and stress. We will guide you through the whole process, making sure that you are very clear at every step of the way. I know that estate planning can feel confusing to a lot of people. I actually I had a couple of phone calls today with 3 separate women who all said at the beginning of the call, I know I need to do something. I just don't know where to start. This is where you start. You start with getting educated. You start with learning more about the process, and then you work with a lawyer that you trust to take care of your family. Because ultimately, this is something that you do for the people that you love. And we've designed the entire process to be as easy as possible for you, to support you to actually do the thing that you want to do, the thing that you're here to do. Make a plan for yourself and the people that you love. Because we talked about a lot of risks tonight, a lot of ways estate plans fail. But honestly, the biggest risk to your family is procrastination, that you'll just think about planning, that you'll read about planning, you'll watch videos about planning, you'll go to presentations about planning, but you never actually do it. You never actually take the step and get it done. And then something happens and it's too late. So we are going to offer all of you who are attending on this call and who listen to the recording people, you're going to have to call me and figure out your specific instructions. But if you are here live, here are your instructions on how you're going to get this $1,000 golden ticket offer. We call it a golden ticket offer because it is worth $1,000 of free legal services. So we're not going to give that to you for free. You have to do a few things in order to earn it. It's a pretty large ticket offer. So here's what you need to do if you want the $1,000 golden ticket offer. The very first thing you need to do, find the chat box and put in the chat box golden ticket. You need to put in the chat box golden ticket if you want to be able to be eligible to receive this. So throw that in the chat box, golden ticket. Then you're going to need to schedule your family wealth planning session with me by the end of this presentation. So there's about 5 minutes left. My very handsome husband has thrown the booking link in the chat. You click on the booking link, pull up your calendar while I'm chatting, find a time frame that works for you and your spouse. So you're going to need to schedule that before the end of this presentation. I see lots of people claiming it. Great, claim it, click on the booking link, and start looking at your schedule to find a date and time that works for you. Then you need to commit to completing that inventory of your assets, of what you own before your scheduled appointment. I need you to complete that asset inventory before your family wealth planning session because I review all of your assets. I prepare prior to the meeting so that you get the most bang for your buck, so to speak, out of the meeting. So I can be really prepared. So you have to commit to completing that homework prior to the meeting. And then if you want the additional $250 off, you also need to keep your scheduled appointment. or reschedule it within the next 7 days. So if you keep your appointment or reschedule it very soon, then you get an additional $250 off any planning you might choose to do with it. So if you do those things, you are eligible to receive our $1,000 golden ticket offer. We are offering you guys that to encourage you and inspire you to, do the thing that you came here to do anyway. Get started, have the meeting. Let's talk about the best type of estate planning to take care of your family. So just quick summary, here's how you claim your golden ticket. Throw in the chat, golden ticket. I think most of you have done that. So you've got that step done. Now you go schedule at ogiolaw.com. Click the booking link my husband put in the chat box. If you're married, you and your spouse need to attend this meeting together. When we're married, we do estate planning together. So in order for that family wealth planning session to be free, that $750 meeting with me, you both need to be present. So, and then you just complete your asset inventory. If you do those things and keep your appointment, then you get a golden ticket. So if you're sitting there wondering, okay, do I still need to do this? Do I need to meet with Emily for the family wealth planning session, or can I just kind of DIY this? Can I do this myself? Let me help you get clarity if you don't need to claim a golden ticket. You don't need to schedule a meeting with me. You do not need to schedule a meeting with me, and you can do this yourself right now with cheap or free online resources for where your family is if you do not own anything that would go through the court process. That means you don't own your home. You don't own any other real property, and you have less than $50,000 in other assets. Also, you are 100% clear on who you want to handle things for you, and there are no complications. So you can list at least 3 people. You're comfortable with them making your healthcare decisions, taking care of your kids. Everybody lives close. Nobody fights. It's a simple family situation. You are also very naturally organized, and you are just going to get it done. You don't need any support. You're very type A. If all of that applies to you, so you don't own a home, you have less than $50,000 in assets, super simple family situation, everybody's close, and you're very naturally organized, you don't need any support, then you are a DIYer. So you don't need to schedule a family wealth planning session with me. If that doesn't apply to you, if you do own a home and you have other complications, then put simply, your next steps are put in the chat box, golden ticket, and then schedule your family wealth planning session with me. I'm really looking forward to talking with you and helping you work through these decisions to make the best choices for your family and how to take care of yourself at your incapacity and take care of your kids once you die. If you have more specific questions or you're still not clear on what your next steps should be, you can also go to my website, ogiolaw.com, and you can schedule just a free 15-minute call with me. I can answer your specific personalized questions, help point you in the right direction, and help you get clear on what your next steps should be. I hope that this was helpful. I hope that this gave you some good information about the estate planning process in general, and also what your practical next steps should be. Thank you all so much for spending this evening with me. I really appreciate it. I really appreciate when people take the time to learn about estate planning, because it is such a loving gift to give your family.